Hey, hope everyone can hear us and see the screen. Good afternoon. Thank you and welcome. Thanks for joining us for the second installment in our three-part educational series on the intricacies of mass health. Today's session is Protecting the Home. This focuses on one of the most important and often most asked about topics in planning. We'll walk through key considerations and strategies to help safeguard your home while navigating mass health. A quick note before we begin, today's session is being recorded. So if you'd like to revisit the information or share it with others, it will be available after next week. It takes me a little time to process everything. And also, just want to let you know if you missed part one, the introduction to mass health planning, that recording is already available on our website. If you search under the news and events, it'll be the first thing that pops up. We also invite you to join us for the in-person discussion, which is the same material, but it's a lunch and learn, and it's next week in our office, May 26th at 12 p.m. So if you haven't signed up for that, I can put the link in for that as well. This session will be led by Trisha D'Agostino. She's a partner at the firm, and it's a great opportunity to ask questions and connect. So as we go through the presentation, drop your questions into the chat. We'll plan to address them as we go, if I can, and then we'll also have time at the end. It's now my pleasure to welcome Trisha, who will be leading today's session and sharing her expertise on the topic. Thanks, Trisha.
Thanks, Beth. Hi, everyone. Good afternoon. So we're going to talk today about protecting your home, but I thought I would start first with talking to you a little bit about what you're trying to protect it from, because a lot of the time people come into the office and they say, "Well, about my home in trust, I need to protect my house," but we don't really know what we need to protect it from. We've just heard somewhere on the radio or on television that someone's going to take my house when I need long-term care, and clients typically don't really have an understanding of why or what that means. So just to start at the baseline, this is all about trying to protect your home in the event you need mass health or Medicaid coverage of your long-term care. So what is long-term care? So different types. So one type is home care, when you have someone coming into the home, whether it's family or someone you're hiring from an agency, or another is an assisted living. That is also, it's a form of long-term care. Nursing home care, that's the most common, where we're looking for some assistance from Mass Health. That's skilled nursing facility care. And then totally private care, which isn't covered by Mass Health at all, is continuing care retirement communities, or CCRCs. That's when folks buy into a place like Linden Pond, for example, on the South Shore, and then they pay a monthly fee and they live in that independent living apartment, and then maybe they'll move into assisted living, and then they ultimately do have skilled level care there too. For this presentation, what we're talking about is trying to protect your home in the event you need skilled nursing care covered by Mass Health. The cost of care, just to give you an idea of what it is, these are some national and Massachusetts averages. For home care, according to the Genworth study at the moment, it's about $6,500 a month nationally and about $7,200 a month in Mass. I think that's a hard number to come up with, though, because it really depends a lot on how much care you need at home. So if you're looking at 24 hours of care at home, it's going to be far more than $7,200 a month, probably closer to $20,000 to $30,000 a month. The assisted living facility costs in Massachusetts are around $9,000 a month on average, while nationally it looks like about $5,900 a month. And again, those can go up as well, depending on how much you need in the assisted living. So if you just have a lot of those places have a base cost X per month, and then you have additional charges if you need more assistance with medication management or more assistance with your activities of daily living. So those fees can fluctuate as well. And then nursing home costs in Massachusetts are averaging about $15,500 a month. And we do see some of them coming in a little bit higher, depending on what area of Massachusetts you're in. Sometimes around $16,000 to $18,000 in this area that's closer to Boston. So who pays for all this? So folks either pay privately for the care, or they might have long-term care insurance to cover some of it. But very often when you're looking at skilled nursing facility, which could be that $15,000 to $18,000 range per month, people are trying to get on Mass Health Medicaid. Medicaid is the federal program. We call it Mass Health here in Massachusetts. That's the program that would pay for skilled care. And if you're eligible, what happens is you pay your income to the nursing home. That's your patient paid amount. And then the Medicaid program, Mass Health, would pay the difference. So it's a pretty comprehensive benefit if you have to pay just your Social Security, maybe you have a pension, and then the Medicaid program is covering the difference up to that $15,000 or $18,000 number. Mass Health does provide some assistance with the cost of care at home too, but it is less comprehensive. What happens there is the agency might say, okay, you're eligible financially for home care, you get 30 hours a week, but the individual might need 60 hours a week. So there has to be some funds to pay for what Mass Health doesn't cover. Some of the other home care programs might say you get $19 an hour for the number of hours that you're approved. Again, maybe that doesn't cover the whole nut because either they need more hours or it's more than $19 an hour for the care, so it's $30 an hour. So the applicant is making up that shortfall. So while there are programs out there for the home care, it's less comprehensive. Where you're in a nursing home, you pay your income, whatever it is, less some deductions that you're allowed to make to the nursing home, and Medicaid fills the bucket on the rest. The other thing at home, obviously, you have to think about is, can the person afford to live there with all the other costs that they need to maintain being home? There are some assisted living facilities that also provide some Mass Health assistance. Not a lot. You have to be in an area of the state that participates in the program. And even if you are, not every assisted living facility in that area will be covered. For example, Cambridge is in the city that is covered by Mass Health, but maybe there's only one or two assisted livings in that city that actually have the program. That's different from nursing home as well, where almost every nursing home in the state is going to take Mass Health. So it's a much more comprehensive benefit. What I'm going to talk about today is focused on the nursing home level Mass Health and how to protect your home in that arena. So first, I want to start by talking to you just briefly about how you are financially eligible for Mass Health. So in a skilled nursing home, if you're a single person, you can have $2,000 of assets plus one primary residence. The income, there's no income limit because your income is what gets paid to the nursing home, and then Medicaid pays the rest. So it's an asset limit for nursing home coverage. If you're a married couple, you can have about $162,000 in countable assets plus one primary residence. You cannot give assets away unless it falls under an exception in the regulation without causing a 5-year ineligibility period. So if you have $600,000 in assets, we can't just give it all to our kid to get down to $162,000 and then apply for Mass Health, because that will cause a 5-year look back because you gave assets to someone that was not permissible under the regulation. For home-based Mass Health, it's less of an asset test and more of an income test. So there's income limits for the various programs. There are some asset tests as well, but it depends on the various programs that you're applying for. And I'm not going to get too much into that today because I want to talk more about protecting the home than the actual Mass Health coverage, but we do have a program on that coming up in the coming months if you are interested in learning more about home care. And Beth can remind us when that is at the end. So, and for home care, there is a 5-year look back, meaning you can't transfer assets to qualify for benefits for some of the programs. And again, my partner will get more into that in the next program. But for the home care, you can have a primary residence as well. So for all of these programs, you can generally have a primary residence. So the question is then, why are we trying to protect it? Like, what are we worried about? And what it is if you're in a nursing home and you're otherwise eligible for Mass Health and you have your home, the reason you're trying to protect it is because the agency would place a lien on the home for the value of services it's covering for you every month. And then if the property is sold while you're alive, the agency will get repaid for what it has paid on your behalf from the proceeds of the home. If you don't sell it while you're alive and you pass away, then the agency will get repaid when your estate goes through probate. So the home is in your name, the agency is liening it. When you die, when you file for probate, when anyone dies in the state of Massachusetts and you're probating their estate, you have to notify the Office of Medicaid that they passed away. And the Office of Medicaid then checks to see if there's any claim on the property. They notify you that there is. We've paid $87,500 for Mrs. Smith for nursing home care. We want to be repaid before that when that property sells. So that's what you're trying to protect the home from, is estate recovery and a lien. And it looks like I have a question. So let me see if I can figure out how to find those. Okay. This question says, my brother receives income from a trust my parents set up for his benefit. He lives in their home. The home is titled on the trust, of which I am a trustee. It's a discretionary trust. Would the home be subject to estate recovery if he needs long-term care? So the answer is, I can't tell you for sure without looking at the trust, but we're going to get into some exceptions, some ways to protect the property and some ways that are exceptions to the 5-year look back. And one of them is I'm thinking that your brother's disabled based on from this question, so I'm assuming that he is. So parents can transfer assets to a trust for a disabled child, and so long as that trust is discretionary, the brother can't be trustee, and it's a sole benefit trust for his benefit, then the asset's probably not subject to estate recovery, unless actually the trust terms. It depends. I need to see the trust terms if they require that it be paid to his estate, or they probably don't. And they probably only would have required that if your parents transferred it to the trust in order for them to qualify for Medicaid coverage. If they just did their estate plan and created the supplemental needs trust for the brother and left his share of the inheritance to it, and it's a totally discretionary trust where he's not trustee, it is probably safe from estate recovery if he needs Medicaid. But ultimately have a lawyer just look at that and tell you for sure. So in any case, this is what you're trying to protect it from. So it's basically you can be on Mass Health with a house, but you just are trying to protect the state from getting repaid when you die or sell it so that it can go to your heirs, basically.
Tricia, there's another question there. Did you see that one?
No.
Okay, hold on. I'm sending it again.
Oh, maybe. Okay. So in Rhode Island, a Medicaid lien can be placed on the home only following the death of the owner. Is the rule different in Mass? Yes. It can be placed during life under certain circumstances, one of which is the person is on Mass Health in a nursing home. The person doesn't have a spouse or disabled child living there or someone under 21, so it can definitely be placed on there while they're alive. There are some automatic protections for the primary residence and with no 5-year look back. So I guess that automatic isn't the best word choice there. There are some protections for the primary residence that don't generate a 5-year look back, meaning you can transfer the home in some instances to an individual that's permissible under the regulation that will not start a 5-year clock. And what the 5-year clock is if you give assets away to a non-permissible person, then the person is ineligible for Mass Health essentially for 5 years for giving assets away. So here are some instances when those when you can transfer assets without a 5-year look back. So one is to a spouse. So if you have a couple where one person is applying for Mass Health, you can transfer the home to the healthy spouse, and then the healthy spouse can update their estate planning, and we'll talk about that in a second, and that will not be, there's no 5-year clock there. So, and there's no lien on the property, no estate recovery, because the person in the nursing home isn't an owner of that property anymore. But if you put it all into the healthy spouse's name, you're going to want to update their estate plan, because their estate plan probably says, when I die, everything goes to my spouse who is in the nursing home. And then if that happened, then the agency is going to recover from estate recovery when that person dies. So instead, if you transfer to the spouse, you want to look at their estate plan to potentially maybe create a will with a testamentary trust. That is a way to protect assets for the other spouse if they die first. Or maybe you wait until the nursing home spouse is approved for Mass Health, and then we might do like an irrevocable trust for the spouse, which I'll talk about in a minute. But there's different options depending on the situation, but the bottom line is you can put the home into the healthy spouse's name, and there will not then be estate recovery on the property for the other spouses in the nursing home. This is an automatic protection, which is long-term care insurance. If the person has long-term care insurance that meets the standard under the regulation, when they apply for the coverage of Mass Health in a nursing home, then the state will not try to recover from that property when the person dies. So the minimums under the regulation today are that you need to have long-term care insurance that covers at least $125 per day for at least 2 years. And you have to have some of that policy left when you go into the nursing home and apply. So if you were, like many people, in assisted living first, and you were using some of that long-term care insurance, you just want to make sure you have some left before you apply for that nursing home coverage of Mass Health to make sure that this protection applies to you. Another 5-year look back, sort of escape where there's no 5-year look back, a permissible transfer, we call it, is under the caretaker child exception. So if your child is living with you for 2 years prior to you moving into the nursing home, and if we can get a doctor to certify that that child provided you with the level of care needed to keep you out of a nursing home. In other words, had they not been doing what they were doing for those 2 years, you would have had to go to a nursing home sooner. Then it is permissible to transfer the home to that child with no 5-year look back. So that isn't everyone's situation, but it certainly does come up. And that regulation is there to protect that child so that they can have the home and have a place to live. There's also an exception, as I just mentioned with that question, that for a disabled child, you can transfer your home to a disabled child. So if mom needs nursing home care and disabled child lives in the home, mom can transfer the house to the disabled child or to a trust for the sole benefit of that child. And mom can go on Mass Health. There's no 5-year look back. That trust, if you did a trust or the transfer, you do need to take into consideration that person's benefits and what they are receiving to make sure that is properly structured. But there is a protection here in the regulation that we can get the house to that person versus keeping it in the parent's name and having it subject to a lien. There's also a protection for children under 21. So if the parent has a child under 21, there's a protection where they could transfer the home, and the lien and estate recovery won't be subject to the lien estate recovery. And also, if you have a sibling with an interest in the home. So this does come up on occasion where they have a primary residence that they own with their sibling. And if the sibling has been living in the home for at least 1 year before the person moves to the nursing home, then that is also a protection where we can avoid estate recovery and a lien. If you don't have these things, so if none of those apply and you are just trying to put yourself in a position where you want to protect the home in case you do need nursing home care, so ultimately it will pass to your heirs, there are a couple of common planning techniques that we use. One is a life estate deed, and this is where you transfer the property. For example, the parents transfer it to their kids on the deed, and the parents retain what's called a life estate interest. So on the deed, the kids' names, they become the remainder beneficiaries, and the parents have a life estate interest. This means that during the parent's life, they are the owner of that property. They're responsible to pay all expenses. They would be entitled to any income that's earned if it's rented. And when they pass away, it automatically passes to the kids. That's the advantage of adding them onto the deed. We don't have to go through probate to get the property to the kids. And that is how it escapes estate recovery, because MassHealth gets repaid when the person dies. You file probate and the state gets noticed, and then the state files a claim. If we can avoid the probate by having the children's name on the deed, then it escapes estate recovery. The disadvantage to the life estate option is that the parents own the life estate interest for life. That is a calculation done under the IRS tables to say, depending on how old they are, this is their percentage of ownership, and that changes every year a little bit. So if the property is sold while the parents are alive, then the parent is then entitled to their share of the proceeds, whatever their percentage interest is. So if their life estate percentage is 28%, they would get 28% of the proceeds. So those proceeds wouldn't be protected. So this is a good tool if you are sure that if the parent goes to a nursing home, the kids can keep the property without selling it until the parent passes away. So they would have to have a way to cover the costs. Because as I said earlier, their income, the parent's income, has to go to the nursing home as patient paid amount. So it's not going to be available to pay for maintenance on the home. So if the kids can maintain the home, if the parent needs care, this is something to look at. The advantage is that the parent has all the rights to live in the property and any income while they're alive. And so that's kind of a nice feature. It's a little bit more flexible than some of the trust options, which I'm going to talk about in a minute. But it does have that disadvantage of the proceeds being countable if it's sold. There's also a technical difference there. If someone sells, if you sell your primary residence while you're living and you've resided in the property for 2 out of the 5 years, you can exclude up to $250,000 of gain when you sell it, and a couple could exclude up to $500,000. If their share of the life estate interest isn't that much, like a lot of it is on the remainder side because they're older, they might not be able to take that maximum exclusion on gain. So that's a little bit in the weeds, but I just give you that information. And certainly if you were looking at these options with a lawyer, they would look at the options and explain all of this to you. But that is just another thing that could be a disadvantage with the life estate. And again, doing a life estate, if I want to do this and add my kids on, I'm starting a 5-year clock, meaning I am not going to apply for MassHealth coverage of a nursing home for 5 years because the agency will say I'm ineligible because I gave assets away. So you have to wait 5 years to apply. One more thing on this. This is regarding the primary residence. So the life estate works on the primary residence because the primary residence is a non-countable asset. If the client has a second home, you can't really use the life estate on a second home because now they have a primary residence that's not countable, and then their second home is countable. So if they have a life estate interest in it, it's not excluded as a primary residence. So this life estate deed is specifically for the primary residence and protection of that. The irrevocable trust is the other way that we try to protect the home. And this is the same as the life estate deed, where if you put the property into the irrevocable trust, 5 years after you do that, the property will not be countable for purposes of Mass Health. It will, in this instance, not go through probate because it's in trust, so we don't have estate recovery. And if it's sold, the proceeds are not subject to a lien or won't kick the person off of benefits because the person isn't going to receive the proceeds. Unlike with the life estate deed, where the person will receive their percentage of the life estate interest if it's sold, they will not in the case of an irrevocable trust. Just so to give you an example of that, if you have a single person that has a life estate interest and they can only have $2,000 plus a primary residence, if they receive 28% of the proceeds, that's going to push them over $2,000 and potentially make them ineligible for benefits. Whereas if it was in the irrevocable trust and the trustee sold the property, the proceeds just stay in the trust. They don't go to the person, so it doesn't interrupt their benefits. Some disadvantages of the irrevocable trust are obviously the 5-year look back, just like with the life estate deed. Another is the loss of control, though, because in this case, they don't own the property like they do with a life estate. In this case, we have a trustee who cannot be the parent or the person creating this. It has to be someone else. The trust also prohibits them from having any access to principal. So they can no longer get equity from the property. No one will likely loan to an irrevocable trust as it is, but even if they did, you can't use equity in the property for the parent's benefit because then it would be treated as countable. These trusts can be scrutinized by Mass Health as well, depending on the way that they're drafted. They kind of try to look at the terms and use different terms to treat them as countable, even though they shouldn't be. But the advantages, as I said, are that the whole asset is protected regardless of if it's from a sale or from a state recovery. And you can draft these where even though the person can't have the access to principal from the trust, they could get access to income. So if it's a rental property, like they have either a second home that's a rental and they want to continue to have access to that income, but they don't mind giving up access to the equity, you could use an irrevocable trust and allow for the income to be distributed to the person. The irrevocable trust is different from the life estate as well, where it can protect the primary residence because it's owned by the trust, but it can also protect second properties because now you've put that whole property into the trust, so it's not countable. So we don't have to worry about like that primary residence exclusion like we do with the life estate deed. Revocable trusts that many people have and are commonly used for estate planning. Revocable trusts do things like avoiding probate because property owned by trust doesn't have to go through probate. We can use them to minimize Massachusetts estate taxes. We can use revocable trusts to manage assets for minors, but they do not protect against estate recovery or a lien for skilled nursing facility level services for Medicaid. So a lot of times clients come in and say, I'm all set, I think. My mom put her house in a trust for estate planning. She went to see a lawyer. It's in good shape. And then I look at the trust, and it was this, like a revocable trust, which is a very common estate planning tool and very useful estate planning tool, but it does not provide protection for long-term care. So if it's something that someone did a long time ago, like earlier in their life, and they're saying my house is in trust, I should be okay, it may just be more of this, of like an estate planning type trust versus an irrevocable Medicaid planning trust. So that is just a summary of some ways you can protect the home and what you're trying to protect it from. I don't know if you have any other questions for me, but I'm happy to take them if you do.
Tricia, I'm going to send over a few. Did you see it?
Yep, okay. If the owner is receiving care in Massachusetts, but the house is in New Hampshire, are the protections the same? No, and that's a good question. So the Mass Health doesn't count your primary residence. So you can get benefits even though you have a primary residence. Whether it's in trust and protected is another question, but you can get your benefits. But a primary residence cannot be out of state. They treat that as what's called a former home because you cannot be living in Massachusetts with the intent to remain here and qualify for Medicaid while having an out-of-state property. So if you have an out-of-state property, that would be a good one to consider putting in an irrevocable trust, like if you have a New Hampshire family home or something like that. And if you can make the 5 years, that would be one to put into a trust, because if you do not and you go to apply for benefits, they'll make you list that home for sale. And they'll give you time to do that. So they'll say, I think it's about 9 months that they give you to sell it. And then obviously if you can't sell it within 9 months, you can try for an extension, but you have to show that you're really trying to sell it, not like I'm trying to sell a $500,000 house listed at $3 million so no one bought it kind of thing. It's a good faith effort to sell, but it is not that you don't get the same protection. And then, yep.
Okay, here's another one.
Okay. And then I think this question relates to if we put the property in an irrevocable trust, do you lose the step up in basis and the capital gains tax exclusion because it's no longer like their primary residence or in their name? The answer is no, because the trusts are drafted to, if they're drafted properly, are drafted to preserve the person's capital gains tax exclusion and also to keep the asset in the person's gross estate for tax purposes, even though we're taking it out for Mass Health purposes. And so because it's included in their taxable gross estate, the beneficiaries get a step up in basis. So for anyone who doesn't know what that means, if the parent bought the home for $16,000, which happened to me this morning, and it's worth $2 million, we want to make sure when the kids inherit it, their basis is $2 million, because if it's sold and their basis is the $16,000, there's a tax on gain, which is the difference between the $2 million and the $16,000, which is a hefty tax. So the trust is drafted to keep it in the gross estate, so the beneficiaries get the $2 million basis. So if they sell it, there's no gain, as long as they don't keep it for a long time.
Okay, hold on. Get that?
Yeah, so if the couple owns 2 homes, can the primary home designation be changed from one to another? And is there like a timing around that? So it can be, but you have to show that you've truly changed your primary residence. So where are you filing your tax returns from? What's the address on your returns? Where's your mail going? Who are you actually living there? How long have you lived there? That kind of thing. So you can move your primary residence from one home to another, and people certainly do that. But and there's no specific timing, like, oh, they've lived there for 2 months, so that's enough. It's more like, have you moved there with the intent to remain there, and can we establish that?
Okay, I'm pretty sure I know the answer to this, so I'm just going to read this one to you. We don't have lawyers licensed in Florida for clients who make Florida their permanent residence. Yeah, that's a no.
No.
Okay. And then this one came in through email. What if I am unable to put my home in a trust because as a 40B affordable unit owner, I'm restricted from setting up a trust? Are there alternatives?
I don't know the answer to that. I guess the question would be, what do you own? If you're restricted from putting it in trust, how much of that asset is going to be yours when it's sold versus some other arrangement, I think. So
Okay.
I don't know enough about that. I have to kind of dig into the rules.
And do we have recommendations for people when they want to sign up for long-term care insurance, but do we assist in that, or do we just give a referral on that?
We don't sell long-term care insurance, but we do know some agents that, are reputable, and if you need a referral, you can let us know, but we don't sell it. But that is one way to avoid this is to look at what you need, if you can afford long-term care insurance, and to look at how much that would cost and get comprehensive coverage. And also, obviously, there's the minimum long-term care insurance policy we talked about as well. But it is a good idea to look into long-term care insurance, I think, and see what the costs are and whether it makes sense, so you don't have to worry about these Mass Health rules.
Okay, I'm going to read this one too. It's not a direct question, but mom has a irrevocable trust for 20 years, receiving 24 hours home care. I think the question is, what's the strategy for funding that care when we run out, can't get a home equity loan, etc.?
So I think that would be a situation where you might want to talk to an LDLR attorney to see if mom could qualify for any home care assistance, and what might be able to be done with the current assets that she has left to create eligibility for that, to try to get some assistance from Mass Health to supplement the cost of her care while you're keeping her home for as long as you can. That's what I would suggest. And then if you run out and she's going to stay home and she's not going to a nursing home and all she has left is the money in the irrevocable trust, you'd want to talk to her lawyer about that trust too, to see if there's anything that can be done there.
Okay. And here, this one. Hold on 1 second. Sorry, guys. All right. You see that one?
Yeah. If I sell our house while my spouse is in a nursing home, is it half my spouse's since it's my primary residence now? No. So when if you have a couple and one spouse goes to the nursing home and we put the house over to the healthy spouse, we've also created a space where their assets are down to $162,000 with other avenues. If after the spouse gets approved for Mass Health and this spouse's assets then go over 162, or they want to sell their home and now they have $1 million or whatever, the agency doesn't look at this spouse's assets again. So that's not an issue.
Okay. All right. I think that is it for now. So just before we wrap up, there were a few questions about the recording. Yes, we are going to have it recorded for those who jumped on late, but it will be available on our website, and you'll also get an email at the end of next week. I want to sincerely thank everyone for joining us today, especially on this sunny, hot day. So we hope this was helpful, gave you insight and practical information as you think about future planning. Thank you to Tricia for sharing her time and expertise and guidance with us today. So just, again, the webinar will be recorded and available. Please check out our website. I know for those of you who have attended these in the past, we have a ton of information on our website. It's a really valuable resource, including lots of old webinars, blog posts, all types of content, legal guides. I mean, we really have so much. I think that's one of the things that distinguishes us from other firms. So please use those assets and resources to help. And then we're obviously always here to answer questions and get you started on a process. A few other things. Next week will be our in-person Lunch and Learn, which will be this presentation. But if you want to dig into it more questions come up, please feel free to join us. That'll be May 26th at 12 p.m. at our office, which is at 20 Williams Street. And if you sign up, we'll send out the suite number. And then our final, mark your calendars, which I will come out with, that's going to be home health coverage that Tricia had talked about. in June, and we'll just make sure that those dates are right, that we've got the right people locked in for that. But it is near the end of June. And that'll go out in our e-letter. If you, I'm assuming most people who are on this did get the e-letter. If not, feel free to always forward that to other people too. And with that, thank you so much, and hope to see you at a next event, and hope everyone can get outside a little today. Thanks.
Thank you. Thanks, Beth.
Thanks.